I believe that within a decade, given the elevation of contracts as strategic assets to the business, that we will see within the C-suite the emergence of the chief contracting officer role. I think it's inevitable that we will reach an endpoint where those strategic assets need to be represented on the C-suite.
I'm Hal Marcus.
And I'm Memme Onwudiwe.
And this is Meeting of the Minds, the legal AI podcast from Evisort.
We interview lawyers, professors, and legal operations pioneers that are pushing the envelope.
Leaders using technology to drive great business outcomes and shape the future of the profession.
How you doing, Hal?
Doing well. We just finished our conversation with Mark Ross from Deloitte.
Yeah, no, this was an incredible conversation. Mark's had a great career, from practicing law in the United Kingdom to leading the charge in the transformations in eDiscovery in the 2000s to now heading up and leading off really from its start, Deloitte's Legal Business Services practice, where he serves as principal and growth and market leader at Deloitte Legal Business Services.
Yeah, I really enjoyed talking to Mark. He's had a long career, as have I at this point, so we had a lot of overlap. There were moments I felt like we were on Jaws and like comparing our scars. We talked about early adoption of AI in legal, how to calculate ROI, the rise of ALSPs and the impact they've had, some top strategies for contract transformation. And he had some pretty bold predictions around the impact of agentic AI and the future of the profession that I thought were intriguing.
Yeah, it's always great speaking with Mark. And, when folks talk about the rise of these ALSPs, these alternative legal service providers, Deloitte's definitely a name that comes up. And it's especially interesting to hear Mark's perspective, especially given that he's practiced law in the UK before, because, of course, across the pond, Deloitte can actually practice law.
All right, well, let's share this conversation. Here we go.
Welcome, Mark Ross. We're excited to chat with you today.
Great to be here. Thank you for having me, guys.
Good to be talking to you, Mark. Why don't you start out by walking us through a little bit of your background and how you got into the role that you're in today?
Fantastic. Thank you, Hal. Thank you, Memme. And Memme, always lovely to see you. So I describe myself, and many people will have heard this from me beforehand, as a recovering attorney. It's been, I think, 18 years now since, and actually longer, 20 years since I last practiced law. The first part of my career was as a solicitor in the UK, practicing employment law, litigation, some commercial litigation. And, around about 2003, a lifetime ago, I was involved with the build out and setup of a outsourcing operation to South Africa for the law firm that I was a partner at the time. And I'm being purposeful with the language that I'm using because there were no acronyms to describe it back then. LPO didn't exist as an acronym. ALSP did not exist as an acronym.
Attorneys still said OMG a lot, though, when they talked about it.
They did say OMG, and they laughed me out the room many, many times. But conceptually, it was still a value proposition that resonates today. And I know we're going to be talking a lot about technology as well. But it was centered around leveraging technology to access highly trained, lower cost legal talent to facilitate the undertaking of high volume, templatized legal tasks. And that really introduced me to the art of what is possible in terms of law department and legal task transformation. Fast forward to me meeting my wonderful wife, a California lady who was studying in London at the time. And I found myself emigrating to the United States in 2006 with every intention of taking the bar exam and practicing law in the United States. And Hal, I know that you had a background in this area, but it was right at the beginning of the explosion in the eDiscovery industry, the document review industry, the litigation support industry. And I was left with two simple choices. Number one, study for the California bar exam, which at the age I was at, and having not studied for a number of years, left me with absolute dread, or entering this new industry that was centered around the outsourcing of legal work, at that moment in time, specifically document review relating to the eDiscovery process. So I joined a startup legal outsourcing company at the time. I spent 3 years there. Then after that, I joined a more established legal outsourcing company called Integrion. I was there for over 10 years. The last 6 years of that, I ran their contracts, compliance, and commercial services practice. And I was then headhunted by Deloitte, joining them at the very beginning of 2020, just before COVID hit, which made for very challenging and also interesting times, to launch what we call at Deloitte our legal business services practice. I've been here for almost 6 years now. It's been an incredible journey over that time period, being with the world's largest and most respected professional services organization, really doing day-to-day what I absolutely love, and that's helping some of the world's largest legal departments transform and improve how they operate. That, in a nutshell, is my journey so far, guys.
That's incredible.
So much I can relate to in that background from meeting your lovely wife in California, as I met my lovely wife in California, to the dread of the bar exam, which fortunately I survived, but particularly about the move into eDiscovery and seeing that as a really important trend, a big change that was happening in the space. That was really critical, both for tech and for outsourced legal services. I think that was, right at the epicenter of those coming together. So what was exciting about that? Where did you see a big change happening in the industry related to that?
I think what was particularly exciting for me is that in the UK, I had been involved with the development of a concept, the build out of a workflow. And I'm being a little bit kind to myself, Hal, when I say I was involved in the build out of a workflow. I was not building workflows out in Visio or any other particular technical application. I was scribbling it on a sheet of A4 paper, handing it to my secretary and saying, this is how a workflow impacts a personal injury case less than £10,000 in damages in the United Kingdom. But what was exciting for me is, in reality, this hadn't taken off in the United Kingdom. There hadn't been the same explosion in electronically stored information. The e-disclosure industry was not as advanced from a technology perspective, from an alternative delivery model perspective, as it was in the United States. And I arrived in the United States and was immediately confronted by an array of niche boutique providers, but those with genuine funding behind them, who were invested in the mission of transforming this one particular area of legal practice.
Some people probably know, but just in case some of our listeners don't appreciate it, that is the costliest aspect of litigation, by far, isn't it? Yeah.
By far, there was an astonishing amount of money being expended on this. And again, sympathy is the wrong word. Understanding how this all materialized so quickly In the space of 5 years, we'd gone from bankers' boxes with post-it notes to literally millions upon millions of emails and Word documents and PowerPoint files and Excel files, etc., being subject to the discovery process. And there had to be both a novel, more cost-effective labor solution to that problem and a technological solution. And it took, in reality, in what is the lifetime of the legal profession, in reality, it was a blip in time for the industry to crystallize around solutions to that problem. But during that blip, excessive costs were incurred, and it was those excessive costs which drove the nascent growth of this industry. And while initially in those early years, it was very much focused on litigation, again, in the life cycle of the legal industry, it was incredibly quick before we started to turn our attention beyond discovery to contracting, beyond contracting to due diligence, but beyond due diligence to patent and IP support, beyond patent and IP support to the corporate secretarial function, all leveraging the same lens through which you examine these activities. How could we elevate the legal practitioners of today from the tangle of these everyday commoditized tasks so that those individuals could really do what they were trained to do and provide strategic legal advice to the business? And there were alternate delivery models, be that alternate labor delivery models, leveraging labor arbitrage, or technology that could drive efficiency into those everyday high volume repetitious tasks.
I'm wondering then, if you have any lessons for, the current wave that we're going through right now with AI and technology, any lessons for legal, built upon seeing some of those similar trends in the past?
Well, somebody a lot smarter than me once said, less happens in 5 years than you might predict, and more happens in 10. I largely subscribe to that viewpoint. I think what we are seeing today is a true paradigm shift. And I've lived through the impact of technology-assisted review on eDiscovery and document review. Let's call it first generation AI and its impact on the due diligence process and contract metadata extraction. And now, of course, the promise of generative AI and agentic AI. I genuinely believe that the impact of generative AI and agentic AI is existential in how it can transform the legal profession. And I think the main reason behind that, Hal and Memme, is that for everybody can touch this and feel it and play with it, even outside of their work environment. The number of people who were subscribing to ChatGPT in a matter of months was extraordinary in terms of user adoption. And when you have your kids using it, when your partner is using it at home, when you're using it to book as I did with my wife, to book an itinerary for our 20th anniversary tour of Europe this summer, then you're moving beyond complex terminology that you can't get your head around that was perhaps prevalent in the first iteration of AI. And you have a true driver towards user adoption in the workplace. And that's where I think we're going to see this acceleration of change. All that being said, as I mentioned at the beginning, I do subscribe to less happens in 5 years than one might predict and more happens in 10. Now, 5 might be too conservative. You know, it is still 2+ years ago that generative AI and ChatGPT, hit our virtual screens, and the world, while it has been transformed dramatically, it's not as if we've seen wholesale transformation. But I genuinely think that we will get there in relatively short order. And I'm sure we're going to talk about what that means for the legal profession and contracts specifically.
So since you've opened this, I want to dig a little deeper into this analogy, and I want to see if history is rhyming here or going a completely different place. We both worked, extensively in eDiscovery as technology assisted review became before, and there was a lot of resistance to it on multiple levels. There was the fear of now this is, replacing a lot of attorneys in a room looking at direct emails and advertisements and totally irrelevant nonsense. And then there was the distrust of it from the perspective of, I'm not prepared to say, yes, you've met your obligation for discovery. I don't believe that, has fulfilled what I am looking for, Your Honor. And the back and forth that went on with that, and the gradual evolution of the rules and the guidance and the sense of reasonableness to apply to those standards. Is any of that instructive for where we're at now, or is it just so completely different because it started as more of a consumer-based user kind of situation, and because there were so many use cases?
I think it's instructive. I do think that a lot of the uh, regulations, guidance that was put in place during that first wave, we're benefiting from that today. The toothpaste isn't getting put back in the tube, so to speak. Obviously at Deloitte, we do a lot of work on the ethical, responsible use of AI. And I think more broadly in the legal profession as a whole, it's really incumbent upon the general counsel and the chief legal officer to own their organization's ethical and responsible use of AI. But I do believe that a lot of the work that was done in those early years, we're benefiting from today in terms of the guidance, the scrutiny of the court, all of all of the scrutiny and the interest in data privacy, information security, compliance, safety around forensic collection, evidence, all of those topics are still relevant today. And I'm not saying they're all settled, but I do believe that the fact that the e-discovery industry, forensic collection, data security tackled a lot of those a lot of those topics, that we're benefiting from that today.
Interesting. I'm thinking when you're looking at some of the fact of what you said about AI being in everyone's hands and the fact that everybody these days is touching AI and using it day to day. It goes beyond legal, and Deloitte has consulting arms, tax arms, legal arms. How does that allow you to kind of approach this from a multidisciplinary perspective?
Well, that's a tremendous question, and honestly, Meme, even outside of AI, if there was one driver behind my career choice in joining Deloitte, it was a recognition that the legal department, where I'd focused all of my efforts the preceding 15 years of my time in the US, that the legal department was inevitably becoming more of a strategic advisor to the overall business, and that it was impossible for the general counsel, for the chief legal officer to thrive inside the enterprise without being more connected to the overall business, the overall strategy of the business. And if you are a service provider serving that chief legal officer, the general counsel, the law department, it became obvious to me that having expertise from across the enterprise was becoming increasingly necessary to succeed in advising the legal department. It was no longer sufficient to just understand contracting within the silo of the four walls of the legal department, because a contract doesn't belong just to the legal department. As a number of our friends in this space have said many, many times, touched by everyone, owned by no one. Strategic business assets. And I know that these are cliches. I know that these are strap lines, but they exist because they're true. And every single day of my life at Deloitte, every single day, I am engaging with subject matter experts, partners, managing directors, SMEs from across the Deloitte spectrum. People who are experts in supply chain optimization, source to pay, quote to cash, digital transformation, experts who are intimately familiar with enterprise platforms, Ariba, Salesforce, Oracle, of course, Workday. These are tools that, in order to succeed in law department transformation, you absolutely must be able to call on experts who are intimately familiar with those tools, with that entire enterprise technology stack. And within the boutique legal process outsourcing or ALSP providers, don't get me wrong, I will be eternally grateful for the foundation that I received in that industry for 15 years. But it was increasingly obvious to me that in order to be able to serve my clients with distinction, to be able to take the law department on a true journey of transformation, again, another cliche, but genuinely take them to a place where they were leveraging technology appropriately, their operating model was efficient, their spend internally and externally was optimized, that I needed to be somewhere where I could call on the true power of cross-functional enterprise, multidisciplinary expertise. And that's why I joined Deloitte, Memme.
I love that. I love that. And I think that so much of that is, so much of that is why we joined Workday, right?
Of
That
course.
you're able to have kind of a broader, perspective across documents from, from finance to HR, all across IT documents as well. What's also interesting, we did a recent survey and found that literally over 75% of folks in the business don't know who owns the contract, to your point, right? And so I think you'll see that we've actually went from kind of talking of things as contract intelligence, frankly, to more just document intelligence, because in reality, it's really about structuring unstructured data with the focus on documents, and giving you that kind of, vision and perspective. I mean, I just, when I think about, folks working across, across different business units inside of a business on these different types of documents, do you have any suggestions for best practices for maybe, legal departments and such who haven't flexed this muscle in the past?
So I do think that at the highest level, the chief legal officer needs to be best buddies, joined at the hip with the other members of the C-suite, the CFO, the CPO, the chief strategy officer. They need to be aligned, and the CLO needs to fully understand and embrace how his or her department is helping drive the business goals. It is no longer sufficient for the CLO to be exclusively focused on risk mitigation. I think the CLO needs to be focused on business growth, on business enablement. And with that mindset, with that mindset, the legal department can very much be transformed from the, and I say this tongue in cheek, transformed from the department of no to one that is viewed as a strategic enabler of the business's long-term priorities. Now, I also think that when you're talking about contract lifecycle management, obviously one of the topics that's dear to both our collective hearts, understanding that legal has a role to play, of course they do, but legal should not be the one-stop shop for each and every contract request that is generated through the organization. It's not economically sustainable. It's unnecessary from a regulatory compliance and risk perspective. It can lead to bottlenecks in the overall business performance. So I think embracing the fact that legal is an interested stakeholder, a key stakeholder, and in some situations will own components of the process, but procurement will own parts of the process. IT will own parts of the process. Sales will own parts of the process. And understanding how all of these constituent stakeholders interact with one another for the benefit of the overall enterprise, that's pivotal.
So let's delve a little deeper into this, because this is a fascinating issue, and it's more complex than I think it often gets talked about. Undeniably, what you're saying is right, that legal should not be a bottleneck to all the other organizations. It needs to be serving them. It needs to be going at the pace of business. But then it is ultimately going to be responsible for something going wrong, for risk that gets introduced into the business. They're going to be looked to as the enforcer when there is a problem or a disagreement related to the contract. And if they can't enforce it effectively because something was not as it should have been, they're going to own that. So they're more than a stakeholder. They've got a higher degree of responsibility. But those two things are not mutually exclusive. They can empower the different teams and yet still meet all those responsibilities, right?
Of course. But then I would also say, Hal, that not every contract by any stretch of the imagination is created equal from a risk to the organization perspective. And 80% of the contracts that flow through your Fortune 500 enterprise organization are relatively routine. They are capable of being templatized. You can leverage technology to risk score those contracts, to summarize those contracts, to help create first drafts of those contracts, to redline a counterparty's template, etc., etc. And the reason being is, a lot of those provisions are relatively standard. I think where legal truly provides value, it's in those exceptions. It's in that, whether it's 5%, 10%, 20% of the contracting throughput of the organization, it's where there are bespoke terms. It's where the contract value is of such a where the contract value is of such a significant amount to be material to the overall organization. So I think understanding those buckets of contracts where legal truly has to own from start to finish, as opposed to playing a role in the overall management, I think that's key to the whole process.
Yeah, I guess a question I have for you, because we're talking about legal being in the arena now with the other business units, but to speak that language, you have to be talking about value delivered. You have to be talking about ROI. Do you have any tips for folks looking to measure ROI of, AI implementations, CLM implementations, just the various things? How do people come up after that year and kind of actually prove that they've been effectively using their resources?
Another tremendous question. So we do a lot of work in helping our clients demonstrate the ROI, build a business case for contracting transformation. And we find that we see value really falling into three buckets. And not all of these buckets are as easy to quantify the ROI. Number one, the easiest is process efficiency. So whether it is through workflow, AI, dynamic clause libraries, robotic process automation, process efficiency, i.e., being able to complete tasks faster and more efficiently than you were before, that is going to drive cost efficiency into the process. And whether or not you've undertaken an as-is analysis of how much time and by whom is expended on the various tasks in your contracting workflow, or you leverage some of the external market resources that are out there and available that quantify the level of time and effort expended on these tasks, it is not the most difficult task in the world to make assumptions regarding the level of efficiency gains realized from the institution of CLM technology and process reengineering, and how much that ultimately realizes in dollars saved through efficiency gains. Then bucket number two, Hal, would be closing the value gap. So there've been a number of surveys. Deloitte has done them in conjunction with World Commerce and Contracting, formerly IACCM, that talk to how much value is lost in a contract through ineffective contract management. I think our most recent survey on this topic came up with about 8.6% on average of lost contract value through ineffective contract management. So if you've got the process efficiency gains, you've got closing the value gap. The third bucket is probably the most hard to quantify, and that is the gains from improved compliance. Because what we're talking about there is, the avoidance of things happening because you have effective contract management in place. But really, when we're helping clients build that business case, justify the investment in CLM transformation, we're looking at those three buckets. We're using market data, we're using benchmark information from client surveys, industry surveys, and our expertise to go and help clients build that ROI, build that business case for that contracting transformation journey.
It's that risk reduction that I wanted to ask about, because that is so hard to quantify. It's the proving a negative, right?
Always difficult.
Yeah. But a related area of value that also we sometimes find hard to elicit, but that we know is there, because when the stories pop up, they're wonderful, is the visibility into contract terms, obligations, opportunities, cost reductions within the contract that you're not availing yourself of, like rebates, volume discounts, early payment discounts, and things like that. The strategic value of being able to see a business path that you learn about only because you've got this visibility across such a broad swath of contracts that you see something that others cannot see. Do you have any of those stories, or do you come across those experiences in your work?
Of course, all the time. And I think that's one of the incredibly exciting impacts of generative AI and agentic AI, providing the organization with dynamic, query specific information points based on subsets of contracts, portfolios of contracts, that those insights can then enhance the organization's negotiation strategy. That information really had to be manually collated up until very, very recently. But I think the benefit of large language models and generative AI and pointing the appropriate agentic solutions and the agents at those data sets, that really, really provides not just the beautifully presented charts across a contracting portfolio, but it can suggest negotiation strategies based on those insights. That can be truly transformative to the enterprise.
Yeah, that's massive. I mean, I think those kinds of changes and being dynamic, it is really a brave new world for folks who really want to step in and dive deeper into leveraging these kinds of technologies. Are there any challenges that you've maybe seen folks have in implementing kind of adopting new technologies that you might be able to give some hints to as to how to get past, or just give some of those experiences? Because I think folks can learn from that in as much as these successes.
We could probably spend an entire podcast or maybe a series of podcasts on lessons learned, top 10 tips, things to avoid on CLM implementations.
Well, let's pick our top three right now.
Let's pick our top three.
We like to give value for our listeners.
Okay. So first of all, I think alignment at the client steering committee buy-in. And I'll give you concrete examples here. Yeah. I've been on kickoff calls with major clients embarking on contracting transformation, including CLM, identification, selection, and implementation initiatives, where you've got 2 or 3 key client executives driving the initiative. You've got one client executive who is absolutely transfixed by the latest and greatest generative AI, agentic, contract negotiation, support, intelligent insights. And then you've got the other executive who will turn around halfway through the meeting and go, hang on a second, we can't even find our damn contracts, and we're talking about leveraging agentic solutions to redline counterparty paper. We don't even know where our contracts are. So I do think understanding where your organization is on that maturity model and having a realistic pathway to transformation. The three of us, we live and breathe this industry every single day. When we wake up in the morning, when we go to bed at night, it's what we love. We're passionate about it. We're completely and utterly immersed in it every minute of every day. And I think it's very easy to forget that, some of our clients are not at the absolute leading edge of transformation. And I think
we don't forget that at all.
and I think so that would be tip number one.
Okay, go ahead. Well, wait, before you leave that one though,
go on, please.
We see that all the time, and still our number one question is that someone's trying to resolve when we talk to prospects is, where are my contracts? I'm just trying to get them all together and get them in the same format and get them searchable. That is still top of the list, finding them. But I would take some issue with that point about readiness, because there's more of an ability now to leapfrog over to have going from, we just sort of were able to point the connectors at them. At least we figured that much out. We know they're in that silo, in this repository, and this, and they're all different formats or whatever. But we can bring them all into one place and get pretty deep visibility now very, very quickly. And that was not something that was the case a few years ago.
No, and I agree completely and utterly with that statement, Hal. Don't think that I am suggesting there is a huge elongated gap between building out an intuitive, searchable repository with centralized contract metadata and information and intelligent insights, and then embarking on a Gen AI enabled contract negotiation capability. I'm simply suggesting that A should happen before B. Now, that time period between A and B, to your point, has become significantly truncated. significantly. I'd add another lesson learned. Too many integrations is a bridge to nowhere. Again, a strap line. I think understanding where your key integrations, the bilateral flow of information to and from different systems, doing too much too soon, as I said, can be a bridge to nowhere. And I think that ties into my final top tip would be, I genuinely believe, even with the promise of Gen AI, I genuinely believe that an MVP 19 times out of 20 is a very sensible strategy, and trying to tackle the entire enterprise in one fell swoop is too much, too soon. There are different ways to construct an MVP, whether it's business unit, contract types, geography, but I genuinely believe a sensible pathway for integrations, an MVP, you combine those two building blocks, you set yourself up for a much more successful path to an implementation that delivers true value long-term for the organization.
All right. Now, as I'm on acronym patrol today, I'm going to call out for everyone that when we say MVP, we're talking about minimum viable product.
I hate myself right now, Hal,
not,
for you.
well, not most valuable player, but here's the irony. The one is kind of the other, as you're saying, because that really is a great way to go. A variation on that we see quite a lot. Be curious for your feedback on this, is start your transformation by getting that deep visibility into a centralized intelligent repository of all your agreements, and then focus on building out workflows for pre-signature agreements. Because until you've done the one, you don't know what's good. You don't know what's working. You don't know what's effective. You don't know what your level of deviation is from your playbooks. You don't know if your playbooks are real, because perhaps you deviate from them 98% of the time. So why are you wasting time negotiating over something that you give up all but 2% of the time? Learn all of that so that then you can build your workflows intentionally and bake good into them.
I couldn't agree more, but I would also add to that, we would call that CLM readiness, undertaking contracts discovery, CLM readiness activities. I would also say that a lot of the technologies that we're leveraging day in, day out in our CLM implementation engagements, our contracts managed services engagements, those same technologies can expedite the CLM readiness journey. You can understand what your legacy contracting portfolio looks like. You can understand the makeup of your template taxonomy more efficiently, quicker than ever before by leveraging some of the technologies available. You can leverage these technologies to build out the playbooks that you must have in order to create the return on that investment when it comes to your subsequent CLM implementation. So it's almost like a virtuous circle. The technologies that are available today, that the leading CLM technologies, embrace and embed within their end-to-end functional capabilities, those same technologies you can leverage when you're doing your pre-implementation readiness activities to drive even further efficiencies into the process.
No, that's a great perspective. And I wanted to call back a little bit in the past to the MVPs, the minimal viable products, because I'm just curious on, in your engagements with companies, do you think any tips on what might work differently or better for larger organizations versus smaller organizations? Because we've done this with some kind of planet-sized companies, doing kind of proofs of concepts and able to test across their documents. Always just been with kind of even folks where they might not even have a lawyer on their team, but they just want to connect with the Google Drive folder, make sure the dashboards have accurate data, and then that's their test ahead of time. And so,
of course. So again, I preface my answer, Memme, that I'm really positioning the answer by reference to the majority of the client base that I'm typically working with, and they are large, typically Fortune 1000 organizations, Global 2000 scale organizations. And for those types of organizations, tackling the entire enterprise in one fell swoop is almost impossible. I think you inevitably have to look at it through a business unit lens, the sell side versus the buy side of the organization, whether or not you're tackling a particular geography, or perhaps it's a bucket of contract types that support a given business unit. Of course, for smaller to mid-market organizations, you may well be able to tackle the entire enterprise in one fell swoop. There may well only need to be an integration perhaps into e-signature and nothing else. And in those scenarios, yes, I think it's absolutely conceivable to tackle the entire enterprise. But in my experience, when we're talking Fortune 1000, Global 2000 organizations, having a defined roadmap, a multi-phased approach to tackling the enterprise, 100%. But that MVP, whether it's contract types, business unit, geography, that I think is absolutely essential.
So now we've got agentic AI on it, already a reality to some degree, but certainly on the horizon as a major shift. What are the implications there for not just the traditional legal practice model, of outside legal counsel, but also now for the alternative legal service providers that work with the outside counsel, work instead of the outside counsel? How, now we've got multiple sort of Venn diagrams intersecting here. What's your take on that?
Okay, so I'm going to play devil's advocate with myself for a moment and give you a couple of conflicting perspectives. First of all, Deloitte, unsurprisingly, has done a lot of research in the area of the impact of Gen AI on the professions, including the legal profession. I think in a survey that we did at the end of 2024, 79% of those surveyed in our legal department survey noted that they anticipate generative AI having a moderate to significant impact on how legal workers perform. Massive, massive impact. Now let's talk legal specific for a moment. I remember the very first article that I ever wrote before I moved to the States, Hal and Memme. It was when I was a practicing lawyer in the UK, probably around about 1998, 1999, something along those lines. Actually, maybe a couple of years later, maybe 2002, 2003. It was called Time to Stop Time Recording, The Times They Are A-Changing. A play on the Bob Dylan song. And the premise of the article was essentially the death of the hourly rate. The hourly rate, unfortunately, in my opinion, for law firms, is still going pretty strong to this day. I'll give you another example. You'll see where I'm going with this. When I first joined the alternative legal services provider that I joined when I moved to the States in 2006, I remember being interviewed by Time magazine at the time. And I think the heading, this must have been 2007. And the heading of the article was something along the lines of, "Call my lawyer ... in India." And the premise was talking about the impact on the US legal profession of the rise of legal outsourcing to India. A number of years later, I think it was the New York Times, and this was in the early days of AI being leveraged for contract extraction, machine learning, natural language processing, probably around about 2014, 2015. I can't remember the specific article headline, but it had robot lawyers in the heading. And the premise was very, very similar to the one about outsourcing legal work to India from about 8 years prior to that. I've been in this profession either as a practicing lawyer or in law department transformation since the late 1990s. And there's been a multitude of predictions over that time period. The hourly rate is still in existence today. The US
Little-
and you,
A little
the
bit
US
higher
and,
than it used to be, too.
a little bit higher than it used to be. And the US and UK legal professions are still to many, many thriving. Now, that does not negate for one moment my conviction that law firms, legal services providers, alternative legal services providers, if they do not embrace AI, will be left behind. Those two things can hold true at the same time. You can be dealing with a profession that is remarkably resilient, and you can be dealing with a technology that represents a paradigm shift at the same time. And that's what we're seeing right now.
That's very salient, and I wonder, although you talked about the difficulty of predictions, would like to have you do one little prediction for us, which is just, looking at the role of lawyers, paralegals, legal technologists. We're all wondering right now, what's it going to look like in the next few years? How are these roles changing? Are they just going to mainly be the same? What's your perspective, your take on that? What should we have students who are worried about, with a profession they're going to be graduating into. What skills should folks be, learning to get ahead of things? Or is it kind of, do you think maybe a little bit more of the same kind of traditional core facets?
Great question. Now, I'll give you two concrete examples. At the C-suite, I believe that within a decade, given the elevation of contracts as strategic assets to the business, that we will see within the C-suite the emergence of the chief contracting officer role.
Love that.
That's prediction number one. Whether that individual reports into the CEO, the CLO, the exact matrix, TBD. But I do believe, again, we've talked at the beginning of this conversation about how contracts are touched by everyone, owned by no one. I do believe that with the increased elevation of contracts as not just legal documents, not just frameworks for risk mitigation, but tools of revenue generation, tools for compliance, tools that represent how an organization does business, its reputation in the marketplace. I think it's inevitable that we will reach an endpoint where those strategic assets need to be represented on the C-suite. There needs to be an owner. So that's one role that I think will emerge. Skill sets, there's been a wealth of commentary on this topic. Skill sets within the legal department are going to look very, very different 5 years from now than what they looked like 5 years ago. We're going to see solution architects, functional design requirement experts, industry experts within the legal department, engineers, data scientists, data analysts, and of course, expert legally trained talent as well, all rowing in the same direction, elevating the legal department to be a strategic advisor to the business. But I do believe that the legal department of tomorrow will be comprised of a range of multidisciplinary talent, whereas perhaps 5-10 years ago, it was largely speaking legally trained talent.
Excellent. Well, Mark, thanks so much for your time today. Really appreciate our conversation. Have a great one.
My absolute pleasure. Thank you so much for having me. It was lots of fun.
Meeting of the Minds, the Legal AI podcast, is brought to you by Eversort. To learn more about Eversort and how we can help you contract better with AI, visit Eversort, EVISORT.com.
You can find Meeting of the Minds on Apple Podcasts, Spotify, or wherever else you listen to podcasts. Don't forget to click subscribe so you won't miss future episodes.
On behalf of everyone here at Eversort, thanks for tuning in.